Rosh Ziada, Rosh Ziada and Omar Al-Hawi. Unfortunately, our next panelist, Christina, was unable to join us due to personal reasons. She's also an incredible attorney that's board certified in labor and employment law, and her practice focuses on civil rights litigation. She's currently the head of the civil litigation department at the Constitutional Law Center for Muslims in America, which is a nonprofit legal division of the Muslim Legal Fund of America. She'll be dearly missed for today. Russia is an associate at Hartline Barger in Dallas. She's a proud Palestinian American and fluent in both English and Arabic. Her practices include representing both individuals and companies in employment-related disputes. She's been recognized in numerous publications for her keen legal talent, including the cover of Super Lawyers. Omar joins us from Houston, Texas. Omar owns his own law firm where he represents individuals who have been discriminated against and, with good branding, is known as the anti-discrimination attorney. He found the calling to this practice from a young age when he was being discriminated against at his school and needed to hire an attorney to advocate for him. He now does the same for others. Now, on to the show. So what are we talking about today? From a very high level, we're talking about your rights that you have as an individual employee at different companies. And for those that employ others, what are the rights of your employees and your rights as a company towards them? I think everyone's probably heard of at this point the employment at will doctrine. So this presentation is going to focus on individuals who's with jobs who are wondering what they can and cannot say at work. It'll also help businesses understand their rights there. And we'll reserve probably approximately 15 minutes at the end for questions, but feel free to submit them as we're going along. And like I said, if you've had a job in Texas, you've probably already heard this phrase of employment at will. For most, that means you think you can be fired for any reason. And that's true. You can be fired for good reason, bad reason, no reason at all. But companies cannot terminate you for illegal reasons. And during this presentation, we're going to cover some of the more common legal reasons that you're likely to run into, especially at the intersection of free speech and what you can and cannot say at work. All right, so let's talk briefly about the types of employers. And this is really important because the first step in really determining what your rights are is determining who you work for. From a very high level, you need to understand whether your employer is a public or a private entity. In its simplest terms, a public employer is the government and a private employer is everyone else. Each of these types of entities carries with it its own legal rights, and we're not going to cover quasi-public entities like the airport. But if you are a public employer, the most important implication is the Constitution, which applies to our public employers in the government. Then we have separate laws that will cover everyone else. All right, so what everyone's here to find out: free speech in the workplace. Am I corrected? So Russia, Omar, tell me, am I allowed to say whatever I want at work?
No. Generally, I mean, I think we all love that to an extent, right? But generally, no. You know, you're in a professional setting. You have to abide by certain workplace rules, policies, and procedures. And you don't have the ability to say whatever you want at any point in time while you're at work.
I fully agree. And I think that protection varies based on whether or not, just like you said, Hisham, are you a public employee or a private employee? If you're a private employee, you don't have those same rights.
Right. And I think we've seen a lot of this in the news lately. And in fact, one of the reasons that this topic is coming up now is we're seeing discussions in the news about Palestine, about Israel, about Ukraine and Russia. We've seen it in the past with Black Lives Matter. We've seen it whatever the right is. And the question often comes up is this a free speech issue? Do I have a First Amendment right to free speech? Even when I'm at the workplace. And like you said, it depends on if you're a public or a private employer. Generally, private employers, Constitution doesn't apply. You don't have a First Amendment right when you're sitting at work. Public employers do enjoy some protections from the First Amendment, but they are limited, and we'll get into those details. So these are the three buckets that we're going to discuss. We're going to talk about the private sector and the National Labor Relations Act. We're going to talk about Title VII and the First Amendment free speech. So going to those. Let's start with Title VII, which applies to both private and public employers. Omar, can you tell us first what is Title VII? Why are we even talking
Yeah,
about?
of course. Title VII is the predominant federal civil rights act that protects employees across the United States. If you work for any employer who has more than 15 or more employees, you are protected by this federal civil rights law, which is Title VII of the Civil Rights Act of 1964. So this protects individuals under a variety of different, what we call protected classes. But people can just think of that more as like an identity that they hold: race, color, sex, national origin, and of course, religion being those five. There are also additional protections if for any reason you think that your rights have been disenfranchised on the basis of your disability, of your age, of if you are someone who served in the armed forces, if you're a veteran. There are other protections, pregnancy being another one. But Title VII, being the predominant civil rights law, protects under those five identities or protected classes. Texas has its own law under the Texas Commission of the Human Rights Act, and it's essentially very similar. So if you have a claim under one, you most likely have a claim under the other.
And I think importantly here, national origin is mentioned. So if I'm being discriminated in the workplace because I'm Arab American or Indian American or anything else, Mexican American, is that an issue for public employers?
For public and private.
Okay.
Yeah, so if you believe that you are being treated differently because of either the country you come from or the national origin of your family, that makes a huge difference. So if you make a comment and someone of a different national origin makes an equivalent comment and you are reprimanded and they are not, that's a national origin question.
Mhm. And I think a good example of this in today's climate, and I think that this is probably why most of you are attending, is based on the conflict of Palestine and Israel. Is, let's say you have a Palestinian employee and an Israeli employee, and they both make a similar comment. So let's say the Palestinian employee says something to the effect of "from the river to the sea," and then your Israeli employee says the same comment but in a different context, and one is fired, the other is retained. I think that is a clear example of discrimination. You treated one person more favorably based on the fact that they both engaged in nearly identical behavior. And so that's kind of what we're looking at when we were talking about discrimination is, were you treated differently than someone who does not belong to your protected class?
Yeah. I really appreciate you grounding this in real examples, Rasha. I think it's much more helpful for why everyone's here today. And I think something that even I've been seeing recently is that you'll even have individuals make the exact same comment in the exact same context. So you could have Arab making a comment from the river to the sea and a white colleague make the exact same comment regarding Palestine. And you'll see the Arab get reprimanded or terminated while the white employee keeps their job. That's a race issue. It could also be a national origin issue, depending on the framing. But we've been seeing more and more of this.
Yeah, and that's absolutely right. It's that you've got to treat everybody the same. And in my mind, when I'm looking at these issues, I always keep two things in mind. Why now? And why this person? And why are they treated the same as everyone else? And if you can answer both of those questions, you for yourself, why am I being terminated now? Is it what the company is telling me because it's based on my performance or my attendance or this political comment, or is it some other reason? And then the second portion being, have I been treated the same as everyone else? Because those are the two key criteria, I believe, when reviewing this issue. And it is about everyone should be treated the same. Okay, going to specific issues within Title VII, what does that really mean? So I think most folks are familiar with the discrimination piece. I've been terminated, I wasn't hired, I wasn't promoted. Those are the common forms of you'll see discrimination. Harassment and retaliation are also covered under Title VII. Can you tell us a little bit about how those are different and ways that I would see harassment or retaliation in the workplace and how those might be protected?
Sure. Omar, do you want me to jump in or do you want me
You do harassment, I'll take retaliation. How does that sound?
Okay, that's
Great.
harassment is similar to discrimination, but it's a little more blatant. So discrimination can be the form of, maybe an isolated incident where, maybe someone's called the N-word or something a little more severe than that. Harassment is something that requires maybe a repeated form of discrimination, or maybe something that is extremely severe. So when we look at harassment, we look at two prongs. One is a harassment welcome. Oftentimes, if someone's harassing you, you're not saying, yes, please harass me, I'm enjoying this. So it's usually unwelcome. The other two things we look at is it severe or is it pervasive? And what that means is it, so for example, let's say you're a Muslim woman and you wear the hijab at work. If a colleague comes up to you and yanks the hijab off your head, that's probably going to be considered severe under the harassment prong, and you've then met your obligation to establish harassment. Pervasive, on the other hand, is this something that maybe isn't so severe but happens consistently? So let's say, again, the same example, you're a Muslim woman who wears a hijab. Every day at work, maybe one of your colleagues is calling you a terrorist or a raghead or something to the effect, and it's repeated and it doesn't stop. And if you can meet either of those prongs, typically that's what you need to establish harassment. Again, it's based on the same considerations of discrimination, race, national origin, gender, sex, disability, things, religion, things of that sort. So you are being treated differently than someone who does not belong to your protected group. And that's truly the basis of harassment.
And just to add one important piece, if you feel like you are being harassed in either of those scenarios, whether it's severe or pervasive, it's on you as an individual to go and report that to your manager, your HR folks, but you need to put the company on notice that this is occurring. Because if you fail to notify them, they can't take action to remediate and fix the issue. And that is for the people who are in management or own their own companies that are small businesses. It's important that you take all of those issues seriously and take prompt remedial action, so that you're resolving the harassment that's occurring. Because if this behavior continues, then you adopted it and it's on you, and you may be liable for the actions that have occurred, even if it's from a coworker, a third party, regardless of who is doing this harassing behavior.
And if I could just
And
add
that
to
is
that,
oh, please.
Oh, I'm sorry, Omar. Just to add on to making the complaint, paper trail. This is my employee side hat right now. If you are complaining, put it in writing, email, something that you can always reference, because it's very easy for an employer to say, well, no, you actually never complained, and it becomes your word versus the employer's word. As an employer attorney, it always makes me happy when there is nothing in writing, because I'm like, well, they didn't put anything in writing. Did this really happen? But I think as an employee, you should always cover bases and make sure you have the evidence to back whatever is going on, because it's usually your word versus, this big bad company.
100%. And I think what both of you have just brought up in terms of reporting is a perfect segue to talking about retaliation. So a question I get a lot from individuals who are a little earlier in the process is when I ask, have you reported this to HR? Is there an email? Is there a meeting that we can turn to? Are there notes? I get a lot of, well, I don't feel like HR is on my side. I'm really nervous. What if things get worse for me at work because people find out that I reported something? Which are all legitimate concerns, but legally you have protection. So retaliation is the legal protection that if you report something in terms of how you are being treated, whether it's discrimination or harassment, and then things get worse for you at work. That could be as extreme as you getting terminated, or you were invited to this daily Monday morning meeting and now they've stopped inviting you. All of that is retaliation. And so you have a legal protection if you report any type of discrimination. And something that we often see as a former defense attorney for companies in labor and employment, and now doing this for individuals, when I was on the defense side, retaliation cases were always much more effective against companies than the actual discrimination case itself. Mm-hmm. Because there is a really clear paper trail. There is something you could point to say, I said this was happening to me, and then I can show after I said that, all of these other incidences occurred. Mm-hmm. And so it's really important, like Rasha said, to have a paper trail and to also rest assured that if something does happen to you, you do have legal protection as under retaliation.
I do want to add one more thing. Sorry, I said I wasn't going to speak about
Please,
this topic, so they're
no,
probably
go.
judging me. Um, Very importantly, for retaliation, you can also be someone who is complaining on behalf of someone else, right? So let's say that your dear colleague is being discriminated against or being harassed, and you go to HR and you say, you know, John Doe is consistently discriminating against Jane Doe. Here are the instances of that. And then the company retaliates against you. You weren't the one being discriminated against, but you are the one who made the complaint. So you now hold a retaliation claim. And as Omar said, those claims are typically easier to prove than discrimination. So just keep in mind, you don't have to be the person being discriminated against to complain and then be retaliated against.
And that applies for harassment and discrimination as well. The associational conduct can be protected as well. It isn't always, but it often is that if you are being discriminated against because perhaps your spouse is of a different race, or perhaps they're a protected class, that these same types of protections apply to you as an individual, and that company shouldn't really be taking those into consideration. But all right, so it's just in the interest of time, I'm going to go ahead and go to the next topic, which is the NLRA, the National Labor Relations Act. Most people have probably never even heard of this law because it only applies in the union context. It is a law that governs the relationship between companies and their labor unions. So common ones would be like the Teamsters or United Steelworkers. There, however, is a small discrete portion of this law that applies to all employers, regardless if you have a labor union or not. And it's a really important portion that applies to free speech rights, because the NLRA applies to employers and protects speech that is in the interest of protected concerted activity. That is a term of art that really means any activity that you are speaking about at work, about the conditions of your workplace. A common example would be if you were standing around the water cooler and you were discussing the company's stance on a political issue. Perhaps you work for an employer that's taken a stance on a political issue, whatever that is. If you are around the water cooler and saying, I like or do not like that comment, I like or do not like our leadership's position on this issue, then that could be protected concerted activity and could fall under the National Labor Relations Act. Or if you're talking about truly any condition about the workplace, could lead to these types of protected activities. They are resolved outside of the court. They're resolved a little bit differently. You'd have to take these issues before the National Labor Relations Board, but it's an avenue that's available to most. And it's important to remember this, even for our non-unionized workplaces, when you're discussing or being reprimanded for activities that discuss the workplace. Professor Omar, did you want to add anything? Have you seen this issue pop up?
Yeah, I did actually. A couple years ago, I had some clients who, and I don't remember exactly who they worked for, but essentially the NLRA came to place. And what happened there is it was a protest. My clients were Native Americans. They were protesting the way the company was treating them as part of their union. And so then the company started kind of picking them out and terminating them one after the next.
Right.
And so in that case, it was a clear example of discrimination or retaliation under the NLRA, because what we saw is there were multiple employees who came together to discuss the same concern. They did it in the form of a protest, and then they also took their protest to social media and discussed it on social media. And so in that context, they were protected by the NLRA, and they had a pretty solid claim against their employer for violations of the NLRA. So that would be one example. If you're just talking about something, kind of going on a rant by yourself, it's usually not, they might think you're crazy, but you're also not going to get the protections of the NLRA, right? This is something that you have to have a shared concern with multiple people and be discussing it together.
Yeah, and I think you raise a really important issue, which is this concept of off-duty conduct. We've been talking about things that occur at work, but the activities that you do outside of the workplace can also be protected if they're in the interest of the workplace. A common example that often comes up before the NLRA, and the NLRA has stated before that it is protected, is if you go make a comment about your workplace. It could be something even profane. You could even use curse words. I think the one was, "I hate my effing manager," and they said that is a protected activity because another one of the employees liked the comment on Facebook or Instagram or something along those lines. And they said, yeah, you have two employees who are discussing something related to work. They don't have to make a comment. So those likes and that behavior becomes protected. And when you're looking at off-duty conduct, it's important to remember things you do outside of the workplace may or may not be protected. The same way you'll see employees who engage in protests and then be fired for engaging in those protests. There are ways that if you are engaged in protests, they can be protected. It's a lawyer's favorite answer is it depends, because it does so much depend on the particular facts of your case. But if you are being reprimanded, or if you are going to reprimand somebody for something they did outside of the workplace, it's important to remember it still can be protected. Okay. Moving on to our next subject, we're going to talk about public employers and this First Amendment right to free speech. Russia, do you want to tell us a little bit about that?
Yeah, so this one's interesting. You know, we like to think we live in the land of the free. We can say whatever we want, whenever we want. But I think the reality is you can probably carry a gun at work and be protected, but not your speech. So as far as First Amendment free speech, it only applies to public employees. So if you're a private employee who works for like Google or Walmart or whatever, you are not going to enjoy the protections of the First Amendment. With that being said, there's still a caveat for public employees. That protection is limited. There have to be certain criteria that are met in order for your speech to be protected by the First Amendment. So the first criteria is you have to be speaking in your private capacity. So let's say, for example, you're the police chief for Dallas Police Department. You can't be speaking on behalf of the police department. If you're doing that, you are not going to enjoy the protection of the First Amendment. However, if you're, John Doe off duty and now you're speaking, you're going to be protected if you meet the next two prongs, because now you're doing it in a private capacity. The second thing is it has to be a matter of public concern. So that's where we see a lot of the gray area, is what is a matter of public concern. Typically, if you're discussing, funding, the police department is not getting enough funding. That's probably a matter of public concern. Maybe fraud. The police department gets federal funding and maybe they're mishandling that money and you're discussing it publicly. That is a matter of public concern. It's our tax dollars and where they're going. If you're just generally disgruntled and, don't like, I don't know, your boss and you're talking about your boss negatively, that's probably not a matter of public concern and will not be protected. Now, let's say you've met prong 1 or 2. Prong 3 is where the balancing comes into play. So you have to make sure that whatever you are saying does not interfere with your work. So if you're holding like press conferences outside your job and, now the other police officers can't make arrests, that's probably interfering with your work and is not going to be protected. If, however, you're just generally discussing it, let's say, in front of some sort of committee, or you're doing it, on social media, which is something we've discussed briefly, and you meet these 3 prongs, then your speech will likely be protected. Again, I want to preface that by saying that this only applies to public employers. So if you're a private employee, you do not enjoy First Amendment free speech at work, which I think is a common misconception, where we think we can say whatever we want at work and be protected, but that truly is not the case.
That's right. Good reason, bad reason, no reason at all. We always go back to that at-will doctrine.
Right.
Thank you. Okay, so the next one comes in this gray area that we often see. What is a political issue versus what is a protected issue? And when I'm thinking of political issues, I think I can think of a number of examples. Palestine-Israel could be potentially a political issue. Black Lives Matter, if you're wearing something with LGBTQ rights on it. I think all of those, abortion rights, can live in that space between political and protected. So are my political views also protected at work?
So from a public... Go ahead, Omar, you can go
Please,
first.
no, go ahead, Russia. Please.
If you're a public employee, yes, as long as you meet those three prongs that we previously discussed. So that's really all I need to say about public employees, and I'll let Omar take the private employees.
And for private employees, unfortunately, again, the answer is there is no protection for political activity. You can be fired for that. Again, I would caution you, if you and another colleague who has a different identity than you make the exact same comment, we go back to discrimination. But if you make that comment in a bubble, no one else makes a similar comment politically, you can be terminated for that.
Yeah, and I think of the example I think of in my mind is Whole Foods when they prevented employees from wearing Black Lives Matter masks. And they said, nope, that's political. You guys prohibited from doing that. Another one, actually, our next slide. Everyone probably remembers this picture from Colin Kaepernick, who the kneeling NFL player who was fired. And the courts even decided that this was political speech and not race speech. And so it can blur the line about what is political and what is protected. As much as we care to discuss these issues, it's important to remember the context of where you work, what you were doing, what you're trying to advocate for, and finding those effective methods, because the last thing anybody wants is to lose their job over something they posted on Facebook. This is another example. If you wore it to work, or like the comment, or posted it.
Yeah, and I think we're seeing the kafaya more and more becoming an issue. I'm getting calls about that pretty regularly, and I think we're seeing it in a few different ways. I think I have some clients who are Arab or Palestinian who are wearing it, and when they're being told no, but they have colleagues who are allowed to wear their ethnic garb,
Right.
that's a discrimination issue. But if there's no cultural attachment to the kafaya, and it is a political piece of clothing that you're wearing, that puts it in a separate category. So again, to go to what Hisham said earlier, a lawyer's favorite answer is it depends, but it does. And I think that's really important before someone makes a choice, to just know that there could be ramifications.
Question, anything else?
No, I think you guys hit this nail on the head.
Fantastic. All right, so I know we're here on behalf of the DFW Muslim Bar Association, the Houston Bar Associations. We probably should talk about religion a little bit. How about protection from religious discrimination? If I go ahead.
Yes, regardless of whether you work for a private or a public employee, you are going to be protected from religious discrimination. And like Omar said, Title VII will come into play for both. And I mean, I don't think there's really a way around that, but you have to also have the evidence, right? So some of the examples we discussed is, let's say you're a Muslim employee and you wear hijab, and you're fired for it. And we haven't seen that a whole lot in the US, but I know it's become an epidemic in Europe where they are outlawing the hijab. And I wouldn't be surprised if there are employers who take a similar stance in the US. But let's say that, you are terminated for wearing hijab, but your colleague wears a cross at work and he or she is not terminated. That is going to be a basis for religious discrimination. I mean, you don't really have to have an example for something that's very blatant like that, especially if you're told that's why you're being fired. But, oftentimes it's always helpful to just be able to say, well, these other people will practice their religion at work and they're not fired. We've also seen it, or I've seen it at my employment, on Ash Wednesday, where some of my colleagues will come to work after church and they have the cross on their forehead. And so let's say, for example, that employee is not fired for displaying their religion in that manner, but, I wear hijab and I am. Or, I mean, really any example like that where you are being targeted because of your religion, but, other colleagues practice different religions and they have not been targeted, that's oftentimes going to be a strong basis for religious discrimination. And again, that applies regardless of who your employer is.
Yeah, and I think there's two. One, there's a I don't want to call it famous, but there's a large case against Abercrombie where a woman wearing hijab was fired because it violated the company's no hat policy. So the US Supreme Court said, no, that's unlawful. That policy discriminates on its face. That is protected under the religious really the religious discrimination laws under Title VII. The important thing for everyone on this call and watching this presentation to remember is that just because a company has a policy that infringes on your religion, it may still be illegal. And for you to think about whether it does or doesn't in an equal manner towards all religions. So if a company wanted, and what we're talking about today, my second point about being free speech, is that if a company says we don't want religious symbols at work at all, it is free to do so. But it needs to be fair and equal and say no religious symbols in the workplace or no religious discussions in the workplace. But if they allow some, but not others, perhaps they're big Muslims and they want to talk about Islam every day at work, that's fine. But they should also be comfortable with the Satan worshiper who walks into their office and wants to talk about their beliefs. It's really being that fair and even deal. And Omar, you got something to add as well.
Yeah, a couple of things. This is a bit of a side note, but when you bring up the Abercrombie case, I love that you said famous and then took it back. I did stop at the actual Abercrombie and was the only person taking pictures, which is how you know that I'm a Muslim employment lawyer. But in terms of, I also want to bring up other instances of religious belief where it isn't always as clear, but you can connect the facts. I've had cases where a woman has started wearing the hijab and then started to face adverse action at work where she was demoted or something of that nature. Even if it's not explicit, if the timeline is really clear, that's very helpful, especially if, going back to what Russia said earlier, you report it and you have that paper trail. So having religious belief, or if you ask for accommodation, I've had individuals who started going to Jamaah, they maybe had been working there for 5 years, 10 years, but now we're like, no, Jamaah is really important to me. Once they started asking for that, then they start to see a shift in how they were being treated.
Yeah. These next few slides are similar. Some of the common examples you'll see in the workplace. We talked about hijab, but crosses, Ash Wednesday. Can you be fired for expressing your religious beliefs? And yeah, what if I want to walk into my office and say there's only one real religion?
Well, you guys, I'm sure everyone's heard the saying where, like, at Thanksgiving dinner or maybe at Eid, there are two things you don't talk about, and that's religion and politics, right? Because you always have like Uncle Ahmed who's gonna go crazy and make everyone convert to Islam at the table. Well, I think the same concept probably applies at work. You know, you can wear your hijab at work. You can wear, you know, I'm not sure what what it's called when you wear your hat as a Jew at work, or when you wear your cross. You know, those are things that are acceptable and that are going to be protected under Title VII and the Texas equivalent. However, if you're at work and you're taking the Quran very seriously and you want to convert as many people as possible and you're just going back and forth with your colleague about it, you can be fired for that. I mean, typically that's not going to be protected. Your employer does not have to allow you to use work as a platform to discuss religion. And I think it goes back to what Hisham says. It has to be equally administered. So no one can talk about religion. It's not like the Muslim only can't talk about it. It's no one can talk about it or everyone can talk about it. But if the employer has a policy where this is prohibited at work, and it's neutral on its face, meaning it applies to every religion, then yes, you can be terminated for having these discussions, especially if they begin to interrupt the workplace.
And I think I want to make sure we're distinguishing between they can prohibit discussions about it. They can't prohibit you from practicing it.
Right.
If the practice becomes a different issue. If you need to pray while you're at work, or if you need the Sabbath off to go to Jum'ah because you can't work overtime on Sundays or Saturdays, whatever it is, that's a different analysis. And employers are required to engage in the interactive process with you and accommodate you if it doesn't cause them an undue hardship. But that relates to your practice, not related to the speech around religion itself. So talking about reasons I can be reprimanded or terminated, how about these? How about, can I be terminated if I said, I love Palestine?
I'm gonna go back to what you said earlier. It kind of depends. Are you Palestinian and say I love Palestine? I think that's fine.
Sure.
But if it is a neutral comment that is not tied to a specific identity, yeah, you could be terminated for that.
Yeah. And I think along these same lines, something that's not mentioned specifically here is that very, very common, I think, probably for us to see symbology for the American flag, our American patriotism. I think, especially amongst Palestinians, you're likely to see somebody wear a Palestinian necklace or perhaps like a Lebanese necklace or something that shows the shape of your country or where you're from. All of those symbols can also be considered part of speech. And so along those lines, what if I do decide to wear that pro-Palestinian necklace, or I'm calling for a ceasefire? Or is it the same type of analysis that we're going through?
I think so. I mean, I'm wearing Palestinian Tatri's blazer, and I've worn it to work. And, I think every time I wear something Palestinian to work, I'm like, is today going to be the day where they're like, rush? But fortunately, my employer is phenomenal, and they usually have great compliments for me when I do that. But I think the analysis is similar, right? So are you targeting, this specific person because they're wearing something specific to their culture or to their religion, or are you targeting everyone? So you could say, look, we're here to work. We're not here to, talk about our culture or religion or identity or whatever. We don't want anyone to have a flag or to wear a necklace or, whatever the case may be. If that is the policy, then that is going to be a neutral policy. It doesn't discriminate against any one particular person. But, Hisham raised a good point. If, my American dear friend has an American flag in his office, and then I have a Palestinian flag and they fire me, then, that's going to be a basis of discrimination. So yeah, I mean, it depends is very accurate. A lot of these require a very fact intensive inquiry, and it's going to depend on exactly what happened in your scenario. And so, that's the caveat to a lot of our discussion today.
Yeah. And for the fact intensive inquiry, I want to make sure we're stressing on this, that writing the documentation, sending the email, sending the text to the company, and back and forth from the company to the employee is really important. And I like to remind people, it might be a little self-serving, but journaling or writing notes to yourself, especially contemporaneous notes that you date, are very useful. It helps you remember what happened at that time, and they can be used potentially in a courtroom to serve as like, hey, this is what happened on that day. I know because I regularly journal, or I regularly, me personally, I send myself an email with the notes after a phone call or something that's important. All right, we should talk about social media. We have a few minutes left because I think just about everyone in 2023 uses some form of social media today. And the question is, our employees have limited rights to expression and free speech in the workplace. Does that also apply to social media? What if I'm using my company's Wi-Fi to post? And what if I'm on my home internet and posting? And I think those are kind of the two main ways that we'll see social media. Rasha, Omar, can you guys align us there?
Yeah, I think if you're doing anything on company time, you could also be terminated because you are not utilizing company time in the way that you should be. So I think that is in and of itself. But I also think it depends on the location, depends on the substance of what you're talking about. So does your employer have a social media policy? I think is really important. And if they do or don't. Second, well, if you're doing it on company time, should you be working? And then, of course, what are you sharing? So if there is a company policy, I also think it's important outside of working hours to be thinking about what you're posting. In Texas, we do not have off-duty protections. So if you post something and it is a neutral way in which your company then takes action against what you've posted, that's not protected speech.
And I think we're seeing a rise in this a lot. And we're seeing a rise in Islamophobia, obviously, and anti-Semitism. But we've seen a lot of examples of employees who are being recorded harassing Muslim individuals. And usually they'll post them on like Instagram or TikTok, and they'll be like, okay, social media, do your work. Where does this person work? Who are they? And within 5 minutes, their whole life history. And then usually the employer is notified somehow, and oftentimes the employer takes action and terminates that person for their off-duty conduct. So it doesn't just apply to what are you posting. It could also be what are you saying, on social media, or what are you saying off duty, and does that reflect poorly? Similarly, you see it in the context of a protest. Neutrality again has to be applied. So if Palestinian goes to a Palestinian protest and an Israeli goes to an Israeli protest, the Israeli is terminated, the Palestinian is not. That's going to be discriminatory. But also, what are you saying at the protest? Are you calling for like the extermination of a people, depending on what side you're on? What you're saying and what you're doing also matters. So just keep that in mind in your day to day. And I'm sure a lot of you already know this. Most employers nowadays, before they make a hiring decision, one of the first things they look at is your social media. What are you doing? What are you saying? And that's outside of the context of Palestine and Israel or any other political movement. It's just something that folks are checking now. So yeah, I would be wary about what you post on social media.
And I would, something that we're seeing a lot of recently, or I'll speak for myself, that I'm seeing a lot of recently, is that even if you have a private Instagram, a private Twitter, a private Facebook, if you have coworkers who follow you or you are friends with, that can be taken back to work, and people have been doing that. They will screenshot it, they can send it to your boss. So to just be really aware of what you are posting and who you are posting it to.
Yeah, it's not public if you post it on social media, so you can't later claim it was a private Facebook or something along those lines. You should always just assume whatever you're saying or doing, especially in social media or even just in an email, might one day be on a projector, and 12 people you don't know might be deciding if that's discrimination or not. So it's important to just, the example I like to give is if your grandmother saw you writing this email, would you be okay with it? Okay, some of our resources, and then we'll go to questions. The Muslim Legal Fund of America has a ton of resources and educational series about these exact topics. They go beyond just free speech in the workplace. They cover other topics that you might see, perhaps immigration. Highly recommend those resources. Again, Christina wasn't able to join us today for this presentation, but she's the head of their civil division there. ADC, and then you have Russia and Omer's information as well up there as well. If you guys have additional questions after this presentation, they're fantastic resources. So by my account, we have 14 minutes left, and we wanted to leave some time at the end for questions, and I'll let Fawaz kick those off.
No, thank you guys so much. It was a brilliant presentation, really covering a lot of topics. We understand it's a very delicate space with a lot of nuances, and a lot of questions depend on fact patterns. But we've got some amazing questions that have come through, so I'm gonna spit them off, and then let's see the discussion we get off of it. One of them that we got, just since we were just talking about social media, was we understand that the social media and off conduct is a sensitive area. If someone is sharing neutral, quote unquote, content, either news articles or just plain videos on their social media sites, LinkedIn, and what have you, is that a preferred method to go versus posting my opinion on the topic?
I would say it's you probably have a better argument for, that I'm not supporting any one side. That saying where you should follow what you preach. I do not. I post my opinion all the time, and I don't know how I'm still have a job, honestly, but I think it probably gives you a greater space to argue that this is neutral speech. I'm not supporting any one side. But I think regardless of what you post, you need to just keep in mind, you do work in an at-will state, meaning your employer can fire you for any reason or no reason at all. And you also need to distinguish, or you also need to draw in other examples. Do you know that your colleagues are posting similar content, or maybe content that is one-sided? And if so, and they haven't been fired, again, now you have a claim of discrimination. So again, it depends.
I would be, there is a case out of Texas involving, it was back in the 90s when there was not as much information about AIDS, but there was an employee who went to an AIDS rally, like an AIDS awareness rally. So it's very neutral on its face, and they were terminated for it. And the courts here said, that was not discriminatory or protected activity, despite it being neutral, right? The employer had an ill-informed belief that they could contract AIDS by being at the rally, and they fired them for that reason. So they don't even have to be right about the reason they fire you. They just simply have to not like it, and the default is back to that at-will state.
I had a professor who would always say, and I thought this was a really helpful way of thinking about will. You can wear blue to work, and if your employer doesn't like the color blue, they can terminate you for that. Because I think people feel like they have a lot more protection than they do. But I think that's just a really simple example. If they don't like the color you're wearing, that is not against the law. What is against the law is if they treat you differently based on a protected class.
Perfect. In a similar question here, which will land probably about the same. If I want to criticize my employer because they are falling on one side or the other of a particular issue, such as Israel and Palestine, am I allowed to do that?
Well, I think the answer is you're allowed to do whatever you want, but the consequence is maybe not one you might like.
I think we go back to the issue of, is it protected under any of those laws that we discussed earlier, right? Is it protected under the NLRA? Is that, can you get your other coworkers to join you in complaining about your employer's failure to take a stance or whatever their stance is? Or if you're in the public space, is it something that meets those elements, right? Is it protected speech? Are you doing it as a private employee? In those scenarios, it could be protected, and you could do those things, or you could be like Russia's employer, who is not monitoring it and does not care what you do off work. And just your mileage may vary.
Yeah, and that completely makes sense. I think that's definitely a takeaway from this presentation, that just because you can take action, but the consequences is really what we're talking about. And there is no inherent free speech right, like we've talked about. There's no inherent right to do some of the things that we innately almost want there to be. So then it really becomes a secondary analysis of, okay, let me look at everybody else. Let me look at my policies. Let me look at if there's another discrimination element here. And that's what we want folks to really think about, have a concerted effort into, so what the consequences are and can be. And that's really how we're trying to empower folks.
Something we haven't mentioned yet is that you could ask first, right? You may not like the answer at that point. And if they tell you, no, we would rather you don't post, and then you do anyway, or you'd rather you don't go to that protest and you do anyway, and you're terminated, that raises a different set of questions. But I think you might find that a lot of managers perhaps may be perfectly fine with you attending or going to those types of work events or participating in that type of activity, or don't care.
Is there a statute of limitations on different employment discrimination cases?
Yes, and they're actually shorter than probably all statute of limitations. So if you're raising a discrimination claim under Title VII, you have 300 days from the date of the adverse action, so the bad act, to file a complaint with the Equal Employment Opportunity Commission. So importantly, for discrimination claims, you can't just go file a claim in court. You first have to go to some of these administrative agencies and exhaust your claim there. So 300 days to file a claim with what we refer to as the EEOC. For the state law equivalent, you have 180 days. So even a shorter period of time to file a claim with the Texas Workforce Commission based on discrimination. So very, very short windows. You have to act fast when it comes to these claims.
And then the 300, if it's 300 days, jointly file between TWC and EEOC to make sure you get as much protection as possible. And I will also say, if you are filing without a lawyer, the wait times can be very intense. So if you are finding yourself at day 290 and you make the decision you want to bring a claim, reach out to a lawyer as soon as possible.
That's a really good segue into the next question that came up, which was, Russia, you mentioned the importance of writing things down. And a question that came across was, I don't understand why is writing something down better than me verbally complaining to my boss and, really being pointed and being more expressive?
Sure. Well, I think you should do both. So let me be clear. I think you should verbalize your complaint, but you always need to follow it up in writing. You talk to HR after your discussion, you send an email, Susan, thanks for your time again. Based on our discussions, here are my takeaways. The reason you do that is because, if the company does not remedy your complaint or, fix the issue and you intend to pursue a claim, if all you did was talk to Susan, it's very easy for Susan to say, nope, that discussion never happened. And who's going to support Susan? Everyone else with the company. So if you don't have anything in writing, it's Susan and everyone else she works with versus you, and there's power in numbers, right? So if a jury is hearing 10 people say this discussion never happened, they're more likely to believe those 10 people than the one person who's saying, yes, it did. So that's why I think it's always important to have it in writing, because if Susan says, no, we never talked, then you can show Susan the email and say, are you sure about that, Susan? So yeah, do both, but always, always, always have something in writing.
And I mentioning that as well. It doesn't have to be in an email, right? It can be a self-serving document. It can be your journal. It can be an email to yourself with a timestamp on it on the day that you spoke to HR or the manager. And why does that weigh more? Because people's minds falter, and we know that people forget things between the time they made a complaint and the time you get to a trial in front of a jury. And that it will be several years, usually 2 or 3 years, before you ever see a jury, if you ever see one at all. And having that self-serving document, that contemporaneous document from when it happened, is more evidence in your favor that more likely than not that it did occur. And the legal standard is that more likely than not, a preponderance of the evidence. And the question to the jury will be, well, what more likely than not happened? Did she complain about discrimination and then be fired for it? And if the answer is yes, then you've successfully proved discrimination. That's generally speaking why you want to write these things down, because even if you're just writing it to yourself, people are more likely to believe it if you wrote it down.
Yeah, more evidence the better. That's
Right.
That's true. Switching gears, kind of similar to what we were talking about. What about, okay, I'm not going to engage in heavy social media presence. I'm not going to be posting, but can I sign petitions? Can I call up my senator and yell at them? Can I do things like that without feeling that I can't?
So it's, again, I want to go back to what Russia said earlier. You could do whatever you want, just as a starter, but is it protected? I think is the heart of that question. And I go back to this notion of off-duty conduct. Some states have protection for what you do when you're not at work. California, Colorado, New York, there's off-duty protection laws. Texas does not have that. So if you sign a petition and it is viewed as political speech outside of work and your employer terminates you, then it goes to the next question. Would they have terminated you if you were not Arab or Muslim? And if the answer to that is yes, they would have terminated you anyway, that's a legal termination. If the answer is no, they had someone of a different national origin, of a different religion, of a different race, do something similar or the exact same, they didn't terminate them, then you have a claim.
That's really well put, Omar. When we're talking about the public's a public worker in a public way.
Is Floss frozen for y'all?
Yeah.
Yes. I thought it was me for a moment.
Me too. We'll give him just a minute to come back.
I think while Fawaz is frozen, there is a question here that I think we could pretty quickly tackle.
Sure.
If an employee gets a tattoo on their neck and claims religious reason, does the employer have the right to terminate them over that specifically?
So I think it depends. If your employer has a no tattoo policy and it's neutral, right, then yes, they can. But if your employer terminates you because of the content of your tattoo, so because it's religious, then you can say, you know, well, you're not treating me equally. This other person has a cross on their wrist, or, you know, whatever it is, and you didn't terminate them. So again, it depends on what is the policy. Is it neutral on its face? If there is no policy, does someone else have a tattoo that is religious, but just a different religion than mine? And was that person terminated? And if the answer is no, then you probably have a solid basis to pursue a discrimination claim there.
Yeah. And I think going back to the religious discrimination issue is the tattoo a religious requirement for your practice? Are you practicing your religion by getting the tattoo? Or are you expressing your religion by having the tattoo? It's a different standard for one versus the other. And the reasons that you have that tattoo are going to be important when the employer should ask you, hey, why do you have the tattoo? Because I think they can ask you to hide the tattoo or cover it up, especially if they require everybody to cover it up. Perhaps it's a dress code policy or something along those lines. But I don't believe, but the expression could be unprotected altogether if it's not part of your sincerely held religious beliefs.
Go
ahead,
Hisham.
Yeah, I was gonna just say we moved to the next question about the tattoo because you froze about halfway through your question, so we didn't know what to answer.
No, not a problem. Sorry about that. Clearly technical difficulties on my part. The one question that I was in the middle of was related to, do consultants that work in the public sector also get imbued with the powers of a public employee in the First Amendment speech context?
No, the First Amendment applies to employees. If you're a consultant, typically you're an independent contractor. And independent contractors typically don't enjoy the rights of employees, regardless of whether they're private or public. So let's say you are an independent contractor who works for a private employer. You're not going to get the protections of Title VII or the protections of the Texas state equivalent. And then if you work for a public employer, you won't get those same protections, nor the First Amendment protection. So unfortunately, independent contractors are just kind of their own island that have very, very limited protections.
I'll also add there's one probably small caveat to this, which is if you're a joint employer, if you are a consultant who spends 99% of your time at this public sector employee and you're treated as an employee for all intents and purposes at this public sector employee, I think there might be an argument that you are employed both by your consulting agency and by this public sector employee, in which cases you could be afforded protections under their laws because for all intents and purposes, you are an employee under their laws. That's a very complicated analysis to do and would really require a very strong understanding of what your role is as a consultant and what you mean by consultant. In our world, we really just view everybody as you're either an employee or not an employee. And then those are the protections that come in behind those.
Yeah, I think that's fair. The inquiry, I think typically, correct me if I'm wrong, Hisham, when it comes to determining whether someone's maybe improperly classified, is how much control does this potential employer have over you? So let's say you are an independent contractor, but the person that you're providing services for dictates what you wear, when you come to work, what tools you use, how you do it, has the ability to fire you, write you up, things like that. Oftentimes you can use those various examples to argue, well, you've classified me as an independent contractor, but you pretty much control my life. So I am an employee for all intents and purposes. And I think, you know, like Hisham said, that is going to be a very, very micro analysis of the facts.
Something that I've been seeing a lot recently, which is in terms of independent contractors or contractors more generally, has been with physicians. So a lot of physicians find themselves in one of two camps. They're either an employee of a hospital, and by that I mean you work at Baylor College of Medicine, you are a doctor of anesthesia, you are an employee, your paycheck says Baylor College of Medicine. That's a very easy situation, you are an employee. But for a lot of hospitals, they will work with groups. So you work with a private group within a hospital, and then at some point the hospital can say, we saw this doctor's tweet, We don't love that tweet. We don't want to continue giving them credentialing. That becomes a much more difficult situation. And the majority of case law is a little convoluted, but not particularly on your side, because you are not an employee of that hospital. Oh, go ahead, Hisham.
No, I think in all of these cases, I think you need to call a lawyer. If you're running into scenarios where you are having these problems, that's what we're here to help you solve.
So, and that leads to another good one. Someone posed a question of, okay, I've been discriminated against. I have a successful outcome of that case where the employer is saying, yep, that's what happened. What happens next? Do I go back and get rehired by that employer? Am I given a salary to close out the case? What are the various outcomes that I should expect if it's proven out?
Yeah, I would say.
Go ahead, Omar.
Oh, please go ahead, Rasha.
No, please, you go. I've talked way too much. Please.
Not at all. Not at all. I'm enjoying it. Please.
Well, I think it depends on what exactly is going on behind the scenes, right? So if you're a current employee, you filed a complaint, and your employer says, well, yes, we've substantiated your complaint. I think some of the next steps you can expect is for them to, one, put a stop to what's going on. That's a pretty no-brainer. They need to remedy the issue. It could be, taking an action against whoever has discriminated against you. And oftentimes, when I'm representing employers, if there is a substantiated claim of discrimination, we want to take some form of action against the bad actor. And that could be up to and including termination. And then, ensure that you have a non-toxic work environment where you're allowed to continue to do your job without being, subjected to discrimination. If you were terminated and you are pursuing a legal claim, that's a little bit of a different inquiry. So let's say you're pursuing a claim with an attorney and one, you're negotiating a resolution with your employer, right? You're not going to court. You guys are engaging in this, pre-suit negotiation. Some of the things that you may want to, kind of put out there as potential resolutions could be a rehire. But that's typically not something I would advise an employee to do for several reasons. One, why would you want to work for that company ever again? And two, after going through that with the company, the first time, there's no guarantee that you won't go through it again, especially now that you've taken action. And I'll tell you, oftentimes most companies are not going to even entertain that option because they now know that you're not someone to mess with. You're not scared of pursuing a claim, right? So that is a possibility. We see that more for public employees because, they work for the government, they have longstanding with the government, and typically that is an easy thing to do from a public perspective, a public sector where reinstatement is a huge option. But for private employees, we don't see that often. The second thing you want to request is going to be back pay, right? So you terminated me, I'm now without a job, I'm not getting income, and I want my income. So you start negotiating some sort of monetary settlement. And then assuming you agreed on one, you're going to have to sign some sort of waiver of claims agreement. And so what that means is you're going to agree not to pursue any claims against the company in the future. And oftentimes in that agreement, there's a no rehire reapplication clause where you are agreeing you are never going to work for the company again in the future, nor are you going to even apply to work for them again. So sort of the potential resolutions just depend on whether you're employed or have been terminated, and then what it is that you want to pursue.
It's a really good answer.
I'll also just add on to that,
Please.
that the EEOC and a couple of other government regulators, especially the NLRB, has taken issue lately with these no rehire provisions. So you're seeing them used a lot less often, but to all of Rasha's earlier points that you probably don't want to work there, they probably don't want to work with you either. So probably in the best interest to say, hey, we're going to go our separate ways. And the language that people are using in these rehire provisions, if you reach an outcome, is a lot more broad, more along the lines like, I agree not to go back and work for this. And I think to talk about what the outcome is, it's important to know what damages are available to you if there was a substantiated claim of discrimination, harassment, or retaliation. These are all protected under Title VII of the Civil Rights Act of 1964. And the damages available under all of them are generally back pay, the pay that you would have received had you continued to be in that role or had you been promoted or gone the job. Your front pay, that's from the pay that you were terminated through how long you would have expected to work there. They usually use that in lieu of being rehired. Then you have compensatory damages. So your mental anguish, the punishment damages, those are capped under the statute. And then you're usually entitled to your attorney's fees. You don't necessarily get all of those in an outcome, right? Because if you're reaching a settlement, you've made a compromise not to pursue your maximum entitled damages in exchange for the company not fighting you on that issue. And it's usually what I call like a no fault issue, right? We're both agreeing that there's nothing been resolved. Now, this can look very different if you are getting a judgment from a court, or if the EEOC, if you're a company, the EEOC has sued you. And then you may be required to do things above and beyond what we're discussing now. But from the viewpoint of an individual, these are likely the things that you're likely to receive.
Thank you. Kind of a similar topic, you know, Russia and Omar both spoke about the idea that you've got to be careful because employers are checking social media posts perhaps before they hire you. So in that same context, if an employer withdraws a offer of employment, does that candidate have any sort of recourse or ability to challenge that?
Yeah, of course. It's the exact same analysis for that off-duty speech we talked about earlier. So if that off-duty speech is viewed as something that is purely political and it is not tied to any type of identity, there are other candidates or individuals who even work at the job who have expressed either similar views or opposing views and are allowed to either be hired or keep their jobs. And it can be argued that it's on the basis of your identity, then yeah, you have recourse. But if it's purely political, not in any way showcased to be tied to an identity, or it seems like a neutral policy, then you don't have recourse. And we're seeing a lot of those cases emerge right now. CARE Illinois just did a press conference yesterday about a law student who had their offer withdrawn and they're bringing a case forward. So it really does depend on the fact of that situation.
I think to add to that, something we did not mention, but it's important to note, is that Title VII and the state law equivalent don't only apply if you are currently employed. You can also pursue a failure to hire claim. So if an employer did not hire you because you belong to a protected group, so like your race, religion, national origin, whatever, if that is the reason they did not hire you, you can now pursue a failure to hire claim under Title VII, and the basis would be discrimination. And then pursue the same, remedies that Hisham just laid out. So, just keep that in mind. It's not just because you were terminated or written up. It could be just because you weren't hired at all.
Got it. And this one we've somewhat covered, but it's posed a different way, so probably bears repeating. Okay, I'm not gonna post. I'm not going to sign petitions. I don't want to do that. But what about me just joining political organizations or financially supporting an advocacy organization that I believe in? Is the analysis the same?
I would think so. And again, I think the crux of all of these, the government of the complaints, is always, were you terminated because of that reason? Were you terminated because you joined an advocacy group? And that goes back to that first question I always ask myself when an employee is being fired, which is, why now? Right? What happened today that caused this employee to be fired? Was the last thing I did was join this advocacy group and then I was fired the next day? Well, the temporal proximity, the time between those two events is suspicious. And that would make me raise questions. So if you are on the employer side, you should always tell your employees exactly why you are terminating them and make it crystal clear at every juncture. When you're giving them warnings, when you terminate them, when you deliver that termination letter, when they later ask you during that closing conference, it should all be consistent. And if you're the employee and you have no idea why you've been terminated, and the proximity between me joining a political organization and me being fired are a day apart, a week apart, a month apart, and nothing's happened between those two things, that's a lot more convincing. I think not just for me, myself, as an attorney advocating for you, but to a panel of jurors who are saying this person has received fantastic performance and has worked for the company for 10 years. There was no reason to terminate them. So if you want to join those groups, more power to you. Again, all of the other advice we've given during this presentation still applies. Whether that is considered speech or not, whether that's considered political, whether you've done it, if it's an advocacy organization like a labor union, if you went and joined the Teamsters and were fired, I think you'd have a claim under those labor laws. But I think this general advice stays the same.
And I also want to make sure that there is a chilling effect with speech, and that's part of what's happening right now. So I also want to make sure for someone who's watching this, there is a question of privacy in terms of, are you donating to a charity and then having a parade in your honor saying, I just donated to this charity, making it hyper public, versus you just privately donating in a confidential manner where it's not advertised, you're not sending a note to your employer saying, I donated to this charity. That looks really different. What we're talking about is things that can come back to your employer. Joining an activist organization can come back to your employer. And so that is separate than making a donation to a charity in a private manner.
Very good. Two last questions, I think, then we can kind of wrap up. One of them segues really well into this topic that we were just discussing. Hisham, you kind of mentioned the idea of, as an employer, you're interfacing and hopefully giving a lot of reasons to your employee on a termination basis. Does the employee have rights to record those conversations? And if you're the employer, what should perspective be on that?
Yeah, so this is slightly complicated, but I'll try to make it as simple as possible. First, I'm only going to speak to Texas. Every state, the recording laws are governed per state, so it may differ in other states. There are two types of recordings that you can do. The first one I call a secret recording. I take a recording device, I stick it in my manager's office, and I walk out of the room. That is illegal. You cannot record somebody if you are not a party to the recording. If, however, you have a recording device, say your iPhone, in your pocket during your termination meeting, that is permitted under the laws of Texas because it is a one-party consent state. That means any single person to that meeting can record that meeting, as long as you are in the actual conversation in the room. My advice also differs if you are the employee or the employer about whether you should record those. Call me later for legal advice. But generally speaking, you should, again, like that email or like that letter that you think your grandmother might read, you should just always assume you're being recorded. This session's being recorded, right? So just always assume that you are being recorded, and you should act with civility and act on your best behavior, because you don't know if the other person who's hearing it is recording it, because they don't have to tell you.
I think it's also important to know what your employer's policy is about recording. A lot of employers have a policy forbidding recordings in the workplace. So also be aware of that, because you could be fired for recording because you violated a policy.
Right.
Yeah. Thank you. And the very last one, which really sums this up really well, I feel like I was retaliated against. I feel like I was discriminated against because of something, off-duty conduct, in-person conduct, speech. What should I do next? And maybe this might be a good segue to re-put that slide back up, Hisham, of resources.
Yeah, again, to go back to what Hisham said in the very beginning, to this individual, this is not legal advice, but generally in terms of what you want your next step to be. If you feel like you've been discriminated against at work, report it to HR. Having that paper trail that Russia said, I think that's maybe the most important thing I'm going to keep hitting. When Russia said, have that paper trail, I really want to keep hitting that note. Very helpful. If you've been retaliated against, it makes it even easier if you had a paper trail from the initial act of discrimination. So making sure all of that's really well documented. But then what I tell people is take a moment, breathe. Something has happened to you at work, and that's really difficult, really emotional. But you also only have 300 days to act. It's a very short statute of limitations. And so turn to a resource, whether it be Russia, myself, the Muslim Legal Fund of America, ADC, CARE, an attorney you know, and get legal advice. Again, it doesn't have to happen in the first 10 minutes. I tell people take a day, but then the next day reach out to an attorney.
It's really very well put. And honestly, even if you're not sure if you've been discriminated against, it would be a good course to have the conversation and continue to feel out how you ultimately feel about it. It doesn't mean that just by contacting an attorney, you've committed to a certain path. You're just getting information to empower you to make sure that act or that feeling doesn't continue unchecked. Because as Omar said, there is a clock, and it is important to document things.
And I also think it's important to remember, I will say for a lot of potential clients or clients of mine who are immigrants, there is a desire to write away what has happened to them as just like a normal course of business. That is not the case. There are laws here that protect you, which we've gone over today. And even if you are not 100% certain that something happened to you, it is worth exploring. I often think of one potential client I had, which for me is like the funniest conversation I've had. He was like, no, it's not discrimination. It's just indentured servitude. And I was like, no, sir, it is not. You are being paid, but it is discrimination. And so there are very clear laws and definitions in this country. So talk to an attorney and do not feel the need to just write away what happened to you based on what you think or are willing to accept.
Very well put. Any other closing thoughts by any of the panelists?
Appreciate your time. Thank you so much for inviting us. It was a pleasure.
Yeah.
Really,
Absolutely. Pleasure.
And thank you so much to the Dallas Muslim Bar Association. You all did so much work putting on behalf of Houston, which is clear as the one man not wearing a tie. I want to thank you all so much for your work in putting this together.
No, absolutely. We're really happy we were able to put this panel together for the larger community here in Dallas and Houston and Texas in general. This presentation will be available, so if someone didn't catch it or wants to rewatch some portion of it, we will have it available. We thank, on behalf of the DFW Muslim Bar Association and the Houston Muslim Bar Association, Hisham, Russia, and Omar for their time, their energy, putting in this presentation, and really thinking through the information that the community would need. So thank you all once again, and we'll see you at the next event.
Thank you.
Assalamu alaikum.
Everyone, thank you.